For the legal profession, just like many others, AI isn't coming, it's already here. It's in our phones, our computers, and many of the programs we use on a daily basis, even if we don't always realize it. And despite many of the objections, sitting on the sidelines is no longer an option. Because here's the reality, if you don't adapt, you risk being left behind. So how do you actually use AI in your legal work? In this presentation, Jacob Carswell-Doherty, CEO at Hubble, breaks it all down. You'll learn exactly how to use AI, both ethically and legally, to supercharge your legal practice, and more importantly, understand why failing to do so might not just slow you down, but leave you behind.
So my name's Jacob Carswell-Doherty. I'm the Hubble CEO, and this topic is Dinosaurs and AI Evolve or Be Left Behind, Ethically Supercharging Your Legal Practice. So just to give you a bit of a sense of the value proposition, so we've got a Sydney-based commercial litigation firm, recently adopted AI. They give an estimate to their client in relation to the review of 20,000 documents. Previously, the manual review was projected to take the 3 solicitors approximately 4 weeks. There's obviously risk deadlines being missed, increased client costs, and the like. However, by using AI to initially identify relevant clauses and key terms, the firm completed the preliminary review in 3 days. Solicitors then verified the AI selected documents for relevance and privilege and substantially reduced the human error, speeding up preparation time as well. So the outcome here for the client is 140 hours, solicitor hours saved, which could amount to anywhere from $35,000 plus in fees. As well as that, it's enhanced the accuracy in identifying critical documents early, significantly strengthening the client's position in settlement negotiations. And so this just demonstrates how practical and ethical use of AI directly translates to efficiency, accuracy, and tangible client value in Australian legal practice. So what I wanted to get across here is that AI is not smart, okay? It processes, it doesn't think. AI does not know or understand law. It simply predicts text based on past data. AI will sound confident even when it's wrong. Example, when it's hallucinating fake case law. It cannot apply legal judgment. It just structures text and refines text based on the command. So it's kind of getting trite now to say this, but never assume AI-generated text is accurate, and everything must be verified. Essentially, my paralegals now and my law graduates who work for me have no longer do the research themselves. They are essentially just verifying the research that the AI has done. That's their job now. I just wanted to also not get too technical, but I wanted to explain to you what the AI is doing with the information so that on a technical level, at least you understand that. So let's just say, and this is just an illustration, you upload a letter that you've received from your opponent, maybe because you just couldn't be bothered replying to it or understanding everything that they've written in it at 5 o'clock on a Friday afternoon. So you ask AI to do it for you. Then what it does is it uploads the information, it splits the letter or the words in the letter into small units called tokens, which are just words or word fragments. The AI then analyzes the tokens to understand the context of the information. So it would use words like lawyer, law firm, letter, Supreme Court, litigation, costs, and then send all of those words to associate in the AI program and to compare against a whole lot of other instructions and information that it has. And what it's doing is identifying patterns and relationships between the tokens based on its training data. And then what it does is it predicts and generates a response by selecting the most likely next word or the token in the sequence, building sequences one word at a time. And then it continually adjusts its prediction based on previously generated words, ensuring relevance and coherence to the response. And so So in the case of AI artworks, and there are plenty of programs like that, the first image you will get will just be a wall of pink or a wall of red. And then what it will do is create the image over and over and over and over again, billions of times, until it gives you a Picasso or whatever you've asked it to do. And I'm assuming everyone here knows how Sudoku works. Now, in a Sudoku puzzle, if you have one of those really difficult ones where there's only one number in the row, it's obviously very difficult to then solve the rest of the Sudoku. And so the easier Sudoku puzzles are the ones that have more numbers in the boxes for you to be able to solve. And that's really the way I want you to kind of conceptualize AI and interacting with it. The more information or the more input you have, the more numbers that you put into your Sudoku when you're chatting with AI, the better and easier it is for the AI to understand what you want and to give you what you want. So if you just give it a one number input, you're going to get back something that's very confused. Whereas if you're giving it more and more input data and you're giving it more and more commands, what you get back is going to be more and more what you want, to the point where it will give you what you want first go. So these are some examples of hallucinations and how you can avoid them. So in the left column, we've got good prompts, and in the right column, we've got bad prompts. And so in this first one, we say, list the key principles from Bryant and Smith based on the following case excerpt. And then you copy the judgment, a portion of the judgment, maybe it's just the majority decision from a high court judgment, into the AI, and then you ask it to list the key principles that the court relied on in that case. You're going to get a good result there because you've given it everything it needs to work with. On the other hand, and this is where some of the other practitioners that we've seen in our ethics presentations have fallen afoul, is that they simply just say, summarise Bryant and Smith without actually providing it with any information. And so unless the AI was trained on all high court decisions, which this one wasn't, but there are some that are, it's just going to make it up, because that's what it's there to do. It's simply there to perform almost like a performing monkey for you, to give you what it thinks you want. It's not going to tell you that it doesn't know that information. And so it's going to give you a fake, hallucinated case summary. Another example now, we've got review the following case excerpt and extract the key ratio decidendi. So you copy it in, and it will give you, it'll give you the ratio decidendi if you've actually given it sufficient information. Whereas on the other hand, if you just say, what did the High Court say about undue influence in recent cases? It's just going to make it up. Another one too is we've got, if you're working on a legal argument or you're trying to come up with a draft submission, if you say, look, here is my rough draft, so you're giving it some context for a legal argument, and here you're giving it some very specific instructions. You don't want it to come up with legal argument. You don't want it to make submissions. You're just asking it to improve the clarity and structure while keeping all the legal references unchanged, because you've done all of that work first. You just want to make it readable. On the other hand, if you just say write a legal argument based on undue influence, you're going to get fake cases and misinterpreted statutes. So we've done to death a lot of the AI guidance from courts and regulators and that, but I do feel compelled, and I have to at least have this as for the disclaimer, because what I'm about to show you will only be appropriate if I have given you the disclaimer and made sure that you're clear on what the courts say about what you can and can't do with AI. So in Australia, we've got a number of key, concepts that you need to be aware of. Disclosure. The client needs to know that there's been disclosure. The courts need to know, that client needs to know there's been use of AI and that you're using their information for AI. And then in very specific cases, the courts have said that they need to know whether or not AI has been involved in preparation of X, Y, Z. Certainly there's a blanket prohibition on AI being used for affidavits. Then there must be accuracy and verification. Like I said before, our law graduates and that now, their role is really verifying what the AI has written. And this is to avoid misleading the court, as Brenda talked about earlier today. Confidentiality and privacy risks. I went down the rabbit hole on this one. This could be a whole presentation and seminar in itself, highlighting all of the terrible ways that AI has infiltrated your legal practice. This gentleman over here earlier said he doesn't use AI in his legal practice. I think there's a 90% chance you do. You just don't know that you do. That's just because you might have noticed, all the companies like Samsung and Apple and Microsoft over the last 24 months, there's literally been a gold rush and a race for everyone to have AI on their phones and on their computers, and everything seems to have AI on it now. We've got Copilot, we've got ChatGPT, we've got all of these AI programs. And in doing so, privacy and concerns and confidentiality concerns have been completely overlooked, to the point where I know for a fact that I have signed up our legal practice to disclose information to AI-based companies through that, that thing where they say, oh, we're updating our privacy policy today, just click accept, otherwise you can't use the program. And no one ever goes through and reads the privacy update that comes through when you get it on your phone or your computer. So you just click OK so you can keep doing your job. But what they've done in that is actually include terms like, we're using AI now, and we have access to all of your client information. It's going to be sent to us and the third parties that we work with to provide services, and we're just going to deem that information is not confidential anymore. And it's going to go to Singapore, it's going to go to the US, it's going to go to the UK. And that would be the case for anyone who's running a legal practice with a practice management software that's like Leap, Smokeball, all those sorts of things. So I don't want to go into that too much. I will a little bit. But just be aware of that. The AI is here, whether you like it or not. It's not a question of whether you're using it. It's a question of how you're going to mitigate the risks in your practice. And if you're not doing it already, you're already behind. There's also, and the authorities and regulators and the court have been at pains to explain that there are limits on what AI can do for you, and for practitioners to be aware of that. There has been a little bit of judicial guidance on responsible use, but not much. So, and just to run through this, so the New South Wales Law Society, which I'll focus on, has said that we need to disclose the use of AI where relevant. So our cost agreement, every single one that's sent to the client has a clause in there that says we're going to use AI in the course of your matter. We have an internal policy. If you'd like to see our policy, that's fine, but just keep in mind that to the extent that permitted, you're waiving confidentiality when it comes to that process. And if you don't want us to use it, well, tell us. Next, the question of whether or not that goes far enough, and if you've got to go up to informed consent, you don't, but you should. But AI outputs need to be reviewed and corrected. I've said that. The client data, a lot of the time, unless you've got the consent, must not be put into the public AI like ChatGPT and those sorts of things. AI-generated case law must be verified before submission, and you must ensure that when you're using AI that you're complying. It's not a substitute to say, well, it's not an excuse to say, well, the reason I breached the professional conduct rules was because I was using AI. You've got to use it in a responsible and ethical way. I mean, it goes without saying. And the other one is that, and this is a recommendation across the board, that firms must implement AI policies. You've got to have a policy in your workplace that your employees not only know, but they understand and they've agreed to abide by it. Because you might have the intern coming in to do their placement, and maybe they do some research for you. Well, what if they just use their ChatGPT account to do that and then give you the information or the research without telling you that it was done by ChatGPT? Well, that's going to be on you as the principal of the practice. And so you need to make sure that when you're onboarding your employees, that you've got this policy, you've explained it to them, and that they're using it. My criticisms, I guess, or about the regulatory approaches, there's been an overemphasis on risk without clear guidelines for responsible use. There's a lack of distinction between the different types of AI use, some of which I'll get into next. There's a disproportionate focus on hallucinations and accuracy. These examples where the solicitors have come up with submissions that have the incorrect citations is actually not the real issue here. It's the iceberg, the mass of the iceberg underneath the surface. The tip of the iceberg are these lawyers who have been found to have engaged in unsatisfactory conduct because of submissions to court. But underlying that, there's a whole lot of other issues that were probably never even contemplated in those cases. For instance, breach of confidentiality and the like. And so focusing on that, I think we're potentially missing out on the main game. There's a weak position on disclosure and a question about whether or not we need, say, informed consent from clients before uploading their data into AI. Yes, go for it.
Have you had any pushback from clients on that policy?
None.
Anyone said, no, I don't think we use AI?
We had one client ask questions about it, and then yeah, they were fine with it. But there's never been any.
And when you've got the team to start using it and verifying the receipts themselves, how's that gone? So, what's the team? Is it a dozen people?
Yeah.
Take to it easily? Has there been any pushback? Has there been any changes to products?
It's been harder to get them to actually use the AI programs. So I've said, okay, fine. If you're not going to use them, you're just going to be verifying the output. Say, for instance, if I do some research on something, I'll copy and paste the output and put it into a memo and send it to them and say, check all of this, and make sure that every single citation is correct, every single paragraph reference is correct, and that says what it says. There's also a process you go through, and if you tell ChatGPT that that's what you're going to be doing and you want it to give you the information to enable you to do that, it will give you a better quality of response. A lot of the time, I was reviewing a High Court decision recently, and it was just giving me general vague sorts of comments about what the court found in that case. And I said, no, I actually want you to give me the paragraph so I can go and read it. And the time saving there was that I didn't have to read the whole judgment. I could actually focus on the paragraphs that I needed to. And so I was able to save time on that.
Is there a definition of AI?
There is.
And how broad is it?
Yes, we will be getting to that. And if I haven't answered that question by the end of it, please ask that question again. So just to give you a bit of a sense of some of the risks, we've got a very low risk kind of activity, okay? Drafting an internal administrative email. So let's just say, for instance, and I've got it here, and hopefully this will show. Can everyone see that? Look, I've got the ChatGPT window up. So I can just say, create an email to ask the receptionist to deliver the brief to counsel. Okay? Very simple. There's no issue with confidentiality. I haven't mentioned anyone's name. I haven't disclosed anything, not even the name of the counsel. And here we go. So it's given it to you as almost like a precedent template, boilerplate kind of email. It's very polite as well. It's done it a lot more polite than I usually communicate with staff. And so that's great because it's making me a better boss because I'm communicating with my staff as though they're human beings, which they are. And then that's just the most simple thing. If we go back to here, generating routine non-legal content. Okay, give me and you don't need to, this is a great thing, you don't even need to get the spelling right. You can just fumble it. Give me an email to my builder, this is a true story, telling him that he is a liar and should do the work we contracted to do. And here we got a lovely articulated email to my builder about my frustration with the ongoing work at the moment, and asking him to honour the terms of the contract. Now, as you can see, that's pretty good. The more information that I put into it, so for instance, I did upload my contract that I had with my builder into this, and I had a whole dispute with him over the last couple of weeks, which I'm not going to go into too much. But to give you a sense, that's a low risk thing from my point of view. If it was obviously a client's contract, I would have to comply with the confidentiality obligations first. Next, we've got scrutinising client-provided data. So let's say the client sends me, as they inevitably do, some of them anyway, at the start of a matter, volumes and volumes of information, and potentially if I'm the third solicitor that's been involved, there'll be a whole history with that solicitor as well. Sometimes it can be great to just copy and paste their long-winded emails into ChatGPT, provided I've satisfied all the confidentiality obligations first, to then just give me a summary of the main concerns. And then once AI's done that, you continue the conversation with it and you say, that's great, thank you for that summary that you gave me from the client, that's really helpful. Now, can you just give me an email to the client repeating back what they've sent me so that I know that they know that I know that I've confirmed the receipt of it. And that helps with client satisfaction because now the client's feeling heard. They know that I've got the email, so they're not going to call to follow up and ask me if I've gotten it. And they are also aware that I know all the detail because I'm referring to the detail when I'm pasting it back to them. Now, when we get into the high, it's totally permitted. You can use AI to draft submissions. You're allowed to. In any court in Australia, you can, provided that it's verified, okay? So that someone's gone through and checked all of the references and citations that you've used in there. And then the next one, we've got analyze confidential documents via cloud-based AI. Okay, so let's say that the client has given us, in a family law matter for disclosure, they've given us 10 years of bank statements and 10 years of bank accounts as a PDF that they've extracted from their bank and they've given it to us. Okay, well, on one view, provided you satisfy your confidentiality obligations, you can upload that information to an AI and ask it to give you certain information back so that you don't have to manually go through and do that exercise. Now, this is risky. It's very risky because you can get it wrong and in doing so breach your professional obligations because there is a very specific set of circumstances that permit you to be able to upload a client's bank account into the cloud, or sorry, to AI, okay? And so hopefully I'm going to illuminate some of those examples of when you can do that sort of stuff. And just going back to Brenda's talk today, earlier today, the Supreme Court has said you can use information obtained in the course of a litigation to prepare a chronology. You're allowed to, okay? But you have to do it in a very specific set of circumstances, and those have been outlined in the practice note. So it's not illegal to upload an affidavit into an AI program. It's not illegal to put a whole lot of information that you've obtained from a subpoena into an AI and then get it to review that and give you an output that you want. It's not illegal provided that you tick the box from a compliant point of view, and it's not hard. Okay, get your phones out. We've got a quiz question. Okay, so which of the following presents the greatest ethical risk for solicitors in Australia when integrating AI tools into the management of confidential client data? Determining whether AI-generated summaries constitute original work under the Copyright Act. Ensuring compliance with the duty of confidentiality when AI applications share client data with third-party providers. Assessing if AI-based predictive analytics infringe competition law principles. Clarifying who owns the intellectual property rights in AI-generated legal documents. Okay. So the correct answer is B. Determining whether AI-generated summaries constitute original work is important, but the greatest ethical risk specifically for solicitors managing confidential data relates to ensuring confidentiality and preventing unintended disclosure, maintaining client privilege and all central ethical obligations. without wanting to hark on too much, because I don't want this to be a seminar on the risks of AI, but we've got the Harman undertaking that the Supreme Court has been very clear that you have to be aware of when uploading documents into AI. You risk misleading the court if your if you have AI-generated content that's just wrong. There's confidentiality, not only in terms of protecting client confidentiality under the rules, but also potentially waiving legal professional privilege in the course of uploading documents into the cloud. You may have breach of suppression orders. If a suppression order has been made about a case and you're uploading information about it into the into the AI, we may be breaching those. You may also be bringing the legal profession into disrepute by conducting yourself in a certain way using AI. I just can't stress enough how many ways you can fall afoul with AI, and you might not even be using AI. I had a number of examples where maybe your opponent's using AI, or the example came up before where a client's using AI and doesn't tell you. What if your opponent's using AI? You're aware that there are these hallucinations in what's going up to the court, or maybe there's a barrister on their feet giving submissions which you know to be wrong, and you don't stand up and say something about it. Does that mean you fall afoul of some professional obligation? There's all sorts of ways that AI is going to trip practitioners up. And so I think just going forward, it's important to conceptualize it. And there's nothing original about any of this. There's the paramount duty to the court. So whenever you're using AI, have front and center in your mind. Imagine Andrew Bell is standing over your shoulder while you're using AI. I think that's the best way to approach it. And you say, well, what would Andrew Bell do in this situation? And then go forth accordingly. He's been very clear and thorough in what he has said about it and what he expects from practitioners, and I don't think there's any room for ambiguity now that they've issued a revised practice direction. But then just remember your other duties, your duty to the client to disclose. You've obviously got your duty to verify the AI-generated content, and then confidentiality, data security, being aware of where all this information is going. And then obviously just compliance with practice notes. I have got a list of all of the practice notes from all of the courts, as well as the directions from the Bar Association and the Law Society, which will be uploaded into a repository for you to be able to access and have a look at. So it's all there, but they all sort of say similar things. Okay, I'm going to get into what different types of AI. Maybe what I'll do first is, let's look at what the big end of town's doing with AI, okay? Because I can tell you that I'm certain, very certain, that the reason the Chief Justice issued a revised practice direction at the beginning of this year concerning the use of AI was because the big end of town probably had a conversation about all of the things and the money that they were investing into their systems, and how this practice direction would mean that they wouldn't be able to use those systems anymore. And sensibly, all of them have come up with a great way to navigate these issues. But Clayton Utz are using relativity AI and this thing called New Discover, which consists of private cloud servers with high-speed data processing units. Minters is using IBM Watson with in-house NLP tools, which is a hybrid cloud infrastructure with dedicated AI processors. All of these have different names and different things. There's only two concepts you need to be aware of, and I'll use the example of before we had cloud file storage, and everyone here should remember this transition that we had, where we had our in-house server where all of our files were stored. The emails server was on there, the client files were on there, and then about 5 to 10 years ago, everyone had to move to the cloud, and there were all these debates around where's that information being kept and is it confidential and all that sort of stuff. It's exactly the same debate now. The difference is that we have law firms who are using in-house servers now, so they're going back to the old ways to process data, client data, confidential data, using in-house servers. And they're also using cloud servers to do the AI processing, and they differentiate which one they're going to use based on the client data or the data that they're processing. So if we are doing a chronology for a litigation and we've obtained a lot of this information on subpoena, we are not sending that off to a cloud-based server. So we wouldn't be using Clayton Nutz's private cloud servers to analyse documents that we've obtained under subpoena. But we may be using Holding Redlick's Kira system, or Luminance, whichever one it is, which is an on-premises AI workstation for secure document review. And essentially all that happens is they bring the AI capability in-house and upload the documents in-house, and those systems are probably not even connected to the internet. And so the client data never leaves the premises. It's all on premises. And so they're the two distinctions. Have we got a cloud-based AI program, or have we got an in-house in-house AI program looking at this data? If you've got an in-house one, you have very few confidentiality concerns. You'll get a bigger bill because the upfront cost is a lot higher, but you don't have to worry about as much of the compliance issue. And essentially, I promised Dan I'd delete this slide and it should have been deleted, but it wasn't. A GPU is essentially what does the calculations, these billions and billions of iterations, managing those tokens and creating the associations of the words and trying to come up with a picture of what you want, is done on something called a GPU. And that they're very expensive, and that's why you use cloud-based GPU servers, because they pay for it and you just rent it. Or you can pay to have it in-house, do it yourself, which is what I'm doing. So I'm literally about to dump $20,000 on a new server because it's going to make my life a whole lot easier, and I don't have to worry about all of these same confidentiality issues, and running it in-house. And I'm certain that it will be a cost saving in the short term. And then when it comes to API, I really just want to be clear. If you ever see API in the course of your practice, and you have, because it's been in all of the terms and conditions that you've signed off on for whatever software program you are using, whether it's on your mobile phone, whether it's on your computer, whether it's Leap, Smokeball, Outlook, whatever you're using, I guarantee you that there is an API there. And those APIs are the back doors, okay? They're the back doors into the software programs that you're using, and that's how these companies like Leap and Smokeball are able to offer all of these whiz-bang features, the AI features and the AI research and all of that sort of stuff, because they give another company a back door into their software program, giving them access to all of your client data to be able to offer you the services that they are using to market their software program. And so an API is how they do that. And as practitioners, you need to know what that word is. You need to always ask your suppliers, do you use an API? And if they say yes, which they will, who uses the API, what do they use it for, and what information is going there. So API is not just something that's isolated to AI. It's a big issue that I feel like many people are not aware of. And you'll get an updated privacy policy that gives someone access via an API to your client, and you won't even know. And yeah, so here it's, for instance, I dictated, I did a dry run of this presentation with Dan, and I recorded what I spoke during that into my phone. And then, it's got a whiz-bang AI feature in the phone that will convert the audio into a transcript, written transcript, which I thought was great, because then that'll help me write a script. And then I looked into the terms and conditions. The audio recording goes overseas, gets converted via AI into words, and then comes back, and your phone has written words. Okay, in that case, innocuous. But what if I was dictating a file note about a conversation that I had with a client where we were discussing sensitive things, and that's going off overseas and then coming back, and that audio file and all that data is staying on a server somewhere overseas, and they're using it so that they can train their AI models. That is happening every day, and people don't even realize it. And the lawyers who are doing these things will be inadvertently breaching their confidentiality obligations. And I've talked about some of the features that Leap has. So just back to local. A local offline AI model is fully controlled by user, no external access, ideal for handling sensitive legal documents, runs offline, does not require an internet connection, faster for repeated queries as the data is processed locally, so on and so on. Whereas if we have a cloud base, which is what 99.99% of them are, it's processed on external servers. Who knows where that data is going? Who knows who's looking at it? It will expose confidential data to third parties. It requires an internet connection dependent on server response time for network speeds. General purpose AI, so it's not tailored necessarily to legal, and it's typically subscription based, whereas if you buy a server, it's an upfront cost. But I tend to think if you're going to be a practitioner who's seriously going to be using AI, you should opt for an in-house model because it protects confidentiality, it maintains your obligations from a compliance point of view, it's reliable and it's fast. Okay, so is this one? Yeah, here we go. So we've got the next question. Your practice management software has an AI-powered document review system where all client data, including chat history, is stored on site. All right. However, the system uses an API that sends queries to an external API provider, for instance, OpenAI, Google, or a legal tech vendor for processing before returning the result. So this is what Leap does. All your client files stay on your Leap account, which happens to be in the cloud, but let's say it's in-house. And it has an AI feature that it will review documents, tell you where the matter's up to, tell you if the client's behind on their fees and the like. All your information's still on your system, but it's using an AI to process that. So what's the primary risk in a setup like this? So is there no risk? Since the client's data is stored locally or on site, is your confidentiality fully protected? Or is there a potential confidentiality breach because the data sent via the API could be stored or processed externally? Are you worried about slower performance because all the information has to be sent into the cloud and come back? Or is there a compliance risk only if the external AI provider is based outside Australia? So if for anyone who follows me on LinkedIn, I had a bit of a revelation yesterday because in the course of researching for this, I was like, oh, wait a second, I'm going to check the terms and conditions of our Leap subscription. And sure enough, there's a company called Auto Pty Limited, who have access to all of our confidential information for this AI feature that they have. And I was even able to look and to see who's been using this AI function that Leap has. And what do you know, the law graduates and our practical legal training graduates were actually using this feature of Leap that I didn't even know existed, and to do certain tasks here and there, and I could see what they'd asked it to do. But I looked at the terms and conditions. That data goes to Singapore, it goes to their data centers in the US and overseas. Now, I had a mini heart attack, but luckily, because about 24 months ago, we had actually included a disclaimer in our cost agreement saying that we use AI. We've ticked the box there in terms of confidentiality. But what about all the other practitioners who use Leap who haven't put an AI clause into their cost agreements and their clients don't know that Leap is using AI to access their information and send it overseas? And what's the ratio of people who are using Leap or Smokeball with this feature who haven't disclosed to their client and obtained the necessary consents to waive confidentiality? I'd be very fascinated to know. And what steps did Leap and Smokeball, for instance, take to alert me, for instance, and other principals who sign off on these things, that this change in this program, which was just announced as an update in the course of the normal updates that they have, that it had something that could make me fall afoul of my obligations to my client? I don't remember. I'm sure I'll be shown where I tick the box, at some point. So I think it's a real risk, and that they do it they're using an API, so it's not like they're sending the client file overseas. The file doesn't leave Leap, but there is a process where it's converted and digitized and AIized and sent overseas, and then it comes back, which is still data leaving your premises. So now I've talked way too much about all the terrible things that AI and all the risks. I want to kind of go back to talking about the practical applications for lawyers. I've done a little bit about it. So let's look at some more. So all of the examples I'm going to talk about now assume, okay, I'm not going to do any more disclaimers, assume that you've ticked the box when it comes to confidentiality. Either you've gotten the consent from the client to waive confidentiality, or you're using an in-house server, and so there is no breach of confidentiality because it's not going away, okay? So here we've got a way that you can use it. So we had my email to the builder before, and normally if I'd written that one myself, it would be quite a nasty email, and probably wouldn't be written the way that I'd like. Well, if it was read out in court, I'd probably be embarrassed. So AI can do things like change the tone of what you've written. So let's say you have it's 4 o'clock on a Thursday afternoon, and your opponent in a litigation has sent you something which has made your blood boil, which often happens, and you've immediately started keyboard warrior. The keyboard warrior in you has come out, and you're writing back to them, and you're about to click send. Well, you know how sometimes they say, well, maybe sleep on it or delay the sending of that email before pressing send. Well, what you can do now is just copy and paste that email into AI and just say, make this nicer, or make this more complicated, or make this less complicated. And so here we have an example where it's just a very simple advice that's going to the client. But maybe there's a little bit too much legalese, it's a little bit too formal, and we want to make it a little bit simpler. And so we've got the first prompt up here, which is draft a response to the client explaining their contract contains an exclusion clause. We get this response, which is kind of a bit complicated and maybe not very clear. And so we do a follow-up prompt. We just say, okay, well, we've got the existing one. We don't need to start again with the prompt. We're just saying simplify this and avoid legal jargon and make it easier for the client to understand. But now I think we've gotten something which is a little bit too informal. So it says your contract has a clause that says you can't claim damages in some situations. But don't worry, there are laws that might override this and still give you rights. We should chat to see if we can challenge it. So that's probably a little bit too informal. And so all you need to do in that situation is just to say, oh, actually, make it more professional. And so it's just about having a conversation with the AI program to get it to speak in a way that you are comfortable with. And so in this one, we've got a response which is probably a bit more appropriate. Your contract includes a clause that limits your ability to claim damages, but consumer protection laws may override this in certain cases. We can explore whether these protections apply to your situation and discuss next steps. Now, someone might say, well, it would have been quicker for me just to write that myself rather than having this chat with the chat GPT. This is a very simple example, and in the examples where I've used it, I'm talking about much more complicated issues, much more complicated matters, and the process actually is one. So to give you an example, and I've not done this, but I was reviewing the Supreme Court practice direction, and it said that provided you tick the box and this is an in-house AI server, so you're not sending it off to the cloud, you could upload the transcript from the directions hearing that counsel went to, or maybe the transcript from the day, and you can then give the client a summary of what happened in court and who said what and what the major issues were, without having to even read the transcript or type it up yourself, because you upload the transcript into the AI program and you just say, here's the transcript from court today, give me a summary to the client. You've got to identify who the client is. Say, Kira Lee Young, who's on the transcript, was our barrister, so she's our barrister, and so we want to give an update to her client about what happened to court today, and it will just pick it out from the transcript and give you an email that you can send. So theoretically, that's permitted under the practice direction if you have an in-house AI program. You're not sending it off into the cloud. And so you can just think of plenty of other examples. So for instance, maybe a complicated report from an expert, or some other long document that you need summarised to help you maybe explain it to the client or work out a position. Reviewing draft pleadings that you receive from your opponent and getting it to tell you what's the difference, what are the main difference, is there a new cause of action here or not from what the original pleading said. And then you can from there ask it to write a letter back seeking particulars, or write a letter back to that person saying that we oppose it for these reasons, X, Y, Z. So whilst the example that I gave certainly would have been quicker just to write it yourself, I'm just trying to illustrate that there'll be examples where you can use this and it's going to be far more time effective. Yes?
While summarising a day's transcript would be quicker, if you still have to review it to be satisfied that it was an
Ian, I'll reverse a few slides back, and we've been saying it over and over again: verification, 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 and the most obvious thing is that you would have been there, and so you would have had in your mind what were the most important things that transpired that day.
Sorry, I thought you were talking about something where you weren't even there.
Well, and this is the thing. Let's say you weren't there, right? And so all you're doing is looking at it, what the output is, and you say, okay, well, I wasn't there, so I don't know if these things seem to have been discussed in court on that day. I don't know if they were the most important things. I don't even know if they were all of the things. And so if you don't verify and you just send that off to the client,
an update, you may have omitted something that was actually there. And so there has to be a process or a mechanism that you put in place to verify something. Either ask the person who was there, does this look right? Was that what transpired in the court today? Is there anything missing? Don't just hope that it's gotten it right. And that's the I guess it's a great question, because even if you tick all the boxes with the
compliance side of things, that doesn't mean your obligation stops. You've still got an obligation to deliver competent legal services to your client. So even if there wasn't a hallucination in the information, even if the confidentiality is okay to waive that, you've still got to make sure that your client's getting coherent advice and information from you. So again, here's an example for preparing submissions, which is absolutely permitted, provided that you verify it. So the prompt starts with, prepare submissions on the best interests of the child in grandparent parenting applications. Now, any family lawyer would know that in terms of assessing in terms of the orders that say the family courts can make, the best interest of the child is paramount. And family lawyers would know that the interests of grandparents is not one of the primary considerations when it comes to the best interests of the child. And so what we've got here is that the AI thinks that perhaps grandparents do play a crucial role in a child's upbringing. And in this case of Johnson, the court found that maintaining a relationship with grandparents was in the best interests of the child, even where the parents opposed it. The principle under Section 60CC of the Family Law Act, which is best interests of the child and the factors that go into assessing that, is that preserving a meaningful relationship with extended family members is a key consideration. Well, that's just wrong. And in all the examples we've seen of lawyers falling afoul of the courts and in providing submissions, that's what they've done here. They've just done something like this and just copied and pasted what the AI prompt has said into some submissions. And so there's a few things wrong here. That case doesn't exist. The law does not say that there's a presumption in favour of grandparent contact. The AI sounds confident, but it's not legally reliable. So when I'm using AI, and like I said before, you don't have to get it. You just punch away at the keyboard and something will come up. It doesn't have to be perfect. You've got to start somewhere. And so in this one, the example's full of typos, it's messy, it's unstructured, that's fine. Best interest paramount. Grandparents don't have an automatic right. Section 60CC factors. Relationship history matters. Case where court rejected application because no prior contact. Need to prove benefit to the child. And then you're giving it a bit more context and a bit more direction. And and you're going to get a submission that's going to be a lot closer to reality. And so I think the best way to see the AI, it's like a ghostwriter. Like let's say you're writing your memoirs, right? And you can't expect the person who's writing your memoirs, unless they've studied your whole past and they know everything about you, to do a biography or an autobiography of you without you telling them anything and without you giving them some context. And so it's best to see it as like a ghostwriter. You're kind of getting it to write your memoirs for you or write your autobiography for you so you don't have to. But you've got to give it the information to be able to work with it. Okay, so getting into some more detailed examples of how you can use it. So is there anyone here who doesn't know what a Section 50 notice is? Okay, so in litigation, you often have large volumes of documents. Let's say in a family law matter, which we often find, you've got thousands and thousands of pages of bank documents, and you need to show, and well, you go through it and you discover that the evil husband has been taking out money from the bank accounts over the course of 10 years before finally making the decision to separate from the wife and leave her with nothing. And so you've got to go through every single bank statement and find all of the times that he took the money out of the bank account. So if you then dump every single bank statement where that occurred onto the court, it's going to be a large volume of information. And so a Section 50 notice is an exception under the Evidence Act, which allows you to present large volumes of information in a summary form, in a table. And so in the example where you have an in-house AI system, you simply upload all of the information and you will get an output that can allow you to produce something like a Section 50 notice, which is essentially it takes out the lines from each of the bank statement and then pastes it into a table for you, and it will give you a reference where it is. It will give you a description. You can command it to do whatever you want. And there's no limit to how complicated the instructions will be. You could even come up with some programming code and get AI to use a special script that you've created using AI to do very, very complicated things. There's no limit to what it can do. The limit's only in your imagination. Section 67 notice, so maybe you've got a deceased and all these people are trying to tell the court what the deceased said and when. Well, obviously there could be an issue with admissibility of information like that where the deceased is dead. And so there's a Section 67 of the Evidence Act says that where you're relying on statements from someone who's deceased, you actually have to give notice to your opponent of the particular parts of the affidavits that you're going to rely on, which include statements from a deceased. And so you can actually upload the affidavit into ChatGPT, sorry, not ChatGPT, don't do that, into your in-house AI server, and then tell it, review this affidavit, find all the statements from Dorothy Dix where she's said to have said something, and then give me a table with those paragraphs based on a column for deceased, the paragraph number from the affidavit, what was said, where it was said, the date it was said, and who it was supposed to have been said to. And it will potentially turn a process that might take you hours and hours and hours and hours and hours into literally minutes. And it will give you a table that you can then copy into a Section 67 notice. Now, that's only the first step. You then obviously need to go and verify it by looking at the output, going to paragraph 14 of their affidavit, checking that the statement actually says John always said he wanted everything to go to Mary, check that it was said at the family home, check that it was on the 2nd of June 2023, and check that it was supposedly said to John Doe. And then provided you've done that, you can use it.
But what happens if this is right? Do you have to go through and make sure that...
Absolutely you have to. Yep, but what's being found is that it's actually more accurate and there's less room for error than there was. But look at it this way: if counsel want to make sure that they're relying on it, that there's a particular paragraph that's in, if you've missed something that's critical, someone's going to pick it up because they'll be looking out for it, because obviously you want to get it in. So And if you've got multiple people, assuming you start at the, the basic level where, you do it, then you get the graduate to verify the affidavit, and then obviously you're sending it to counsel, and you're hoping counsel will go and check it as well before it goes back to you, and then before it's served on the other side. So these are all things we do anyway. I mean, if a law graduate does this work, I'm going to go and check what they've done too, because I'm not going to rely on what a law graduate or even a junior lawyer has done in something like this, which is a sensitive, risky process to be engaging in. And then I'm going to send it to counsel because I want to make sure that counsel will verify it as well before sending it back to me. So essentially, it's no different to what we do normally. It's just another tool to use. It's another tool available to use to speed up time and to make things move quickly. I was supposed to take this out. It's made its way back in, but this is an example of using Python script to run a complicated thing. So hands up here who knows Python code. Hey, okay. So Python code's what programmers use. It's the computer games that get made, the websites, they're all based on programming, and they perform functions called scripts. Turns out scripts can actually be quite useful in processing large volumes of data. Where you can actually use AI to create a script for you to process large volumes of data and to give you an output. AI can help you do that. I'm not suggesting that you even try. I'm not going to spend any more time on this slide, but just to give you an illustration of what it's capable of. All right, a final question. Your firm intends to use an AI-driven document summarization tool hosted by an international cloud provider. The AI tool analyzes client documents, which include privileged communications, and generates summaries stored temporarily outside Australia. Under the Australian Solicitor Conduct Rules, which step is most appropriate to comply with confidentiality and ethical obligations? Limit usage of AI tools only to non-sensitive matters. Notify clients generally in any annual letter that AI is used. Update informed consent to each client after clearly explaining potential third-party access and cross-border data flows. Ensure that the AI provider contractually guarantees data encryption. Okay. Look, provided that this question, this answer would be right, provided that you were also compliant, that you weren't uploading, say, affidavits and those sorts of things. So if it was like affidavit material or material that had been obtained under a subpoena, you wouldn't be uploading that to this program because it's not an in-house AI server. So it wouldn't matter whether or not you got consent from the client because you'd be falling afoul of the practice directions and your common law undertakings. But I think really the correct answer here is limit usage of AI tools only to non-sensitive matters in a situation where you've got the data going off. So essentially, and I think that really the takeaway here, AI can do whatever you want it to within certain confines. And if you are going to be using AI, which will be using APIs and data going offshore, only use it for non-sensitive matters. At a basic level, get the client confidentiality waiver, and then see what go for your life with it, provided that you tick the box there. So I think that's. Are there any questions? Yes. Did I answer it?
Not really.
Okay.
I mean, to me, I think you said it before that we're probably using AI without knowing.
Yes.
So should we be, even if we don't specifically have a in-house software or server or whatever, or we don't, most of us would have leave. The issue is, should we be notifying our clients anyway, regardless?
Absolutely. Absolutely. You must have a clause in your cost agreement that says that you use it, even if you don't. And it must say that the data goes overseas, that third parties may have access to your data, and if they don't want that, then they need to tell you. And you could even have in there something saying, we don't use AI tools ourselves, but the software that we license from various third parties may result in your data going overseas. And there's little that we can do to control that. At least you're doing something. You also need, I really think you should have in your cost agreement a disclosure saying that it's not permitted to use AI for witness statements and the like. And if you're preparing a witness statement, do not use AI for it. And so that's in our one. You should also have an AI policy, workplace policy in place, even if you're not using AI, that will cover off all of these issues and at least alert staff members to the fact that these things might be happening so that you can mitigate it as best as possible. And I will have a template AI policy, the template clauses to put in your cost agreement in the file, and you'll get a link to that. So even if you're not using AI, you must act as though you are using AI, because it's everywhere and you can't escape it. And so just manage the risks so that if there is an issue, you can at least say that you did the best that you could. I tend to think that some of these larger software companies like Leap and Smokeball may potentially be letting the profession down a little bit with how quickly they've raced into all of this and sort of forgotten the fundamentals. We shall see how that plays out, but I think you should assume that there are these confidentiality issues nonetheless.
Are only AI systems that small practitioners and individual lawyers can actually use, which will not pass information overseas?
Yes. Yep.
Which ones are they?
They'll tell you, but they'll have their AI data server in Sydney somewhere with Amazon, and so the data's going there. I would imagine Leap, that's how they operate and their programs, and then there are individual bespoke kind of smaller providers who supply sort of services to smaller firms based on what the need is. And they should be able to answer all of your questions. And I think the key is asking the right questions. Is there an API? Where's the data going? Can I be certain of confidentiality? So that at least then you can disclose those things to your clients. Well, so respectfully, that's the incorrect approach, because you will be using it without even knowing. Your computers, your mobile phones are using it, and you don't even realise potentially. Yeah.
Just to clarify that point, is can you avoid all this risk by not using AI and ignoring this disruptive technology?
Well, okay, if you don't use computers and you don't use your mobile phone and you go back to running your trust account through cards and on paper and running your matters through on the old book, yes, that's the only way. Well, just put the policies in place. Just put a clause in your cost agreement. Have the AI policy there, and then that's it.
Of course, then we have to go and sit down and explain it all.
That's right. Okay.
Any other